Can you sponsor your spouse for a marriage-based green card if you are self-employed? That is a question that a lot of our clients ask, and that's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. The past several weeks, we've been talking a lot about H-1Bs and other employment-based matters, and those absolutely are still important for sure. But I wanted to just take a break from that and change gears this week for a family-based topic. So at Sumner Immigration Law, we handle both employment-based and family-based immigration matters. And like I said, it is not at all uncommon for our clients to be self-employed and to want to sponsor their spouses for a marriage-based green card. And you absolutely can do that. Why are people asking this question? Why does this matter? And how do you proceed? The reason that self-employment can be potentially a challenge if you're sponsoring your spouse for a marriage-based green card is the affidavit of support. So when a person, U.S. citizen or permanent resident, sponsors a spouse or some other family members, anyway, depends on what the relationship is as to when you do this. But if you're sponsoring your spouse for permanent residence, then you have to submit, and as part of the process, you have to submit an affidavit of support. It's Form I-864, and it's an affidavit of support that's actually a contract with the federal government that says that you will support your spouse at 125% of the federal poverty guidelines. You may not end up doing that in reality. It may be that your spouse works as well, you split expenses, there may be any different types of setups as far as your financial life together, but the affidavit of support is a requirement for the green card filing. And regardless of how you plan to work out your finances in the future, you, as the petitioner, the U.S. citizen or permanent resident spouse, have to sign this affidavit of support. Most of the time, when you sign an affidavit of support, actually always, but always when you submit an affidavit of support, you have to back it up. So you have to say, yes, this is what my income is, but you have to back up that statement on the form with documentation of your income. So typically, it depends on the situation, but a lot of times that is simply the permanent resident or U.S. citizens' tax returns, pay stubs, and W-2s. It's relatively straightforward. If that U.S. citizen or LPR, permanent resident, the person sponsoring their spouse for permanent residence is self-employed, then it can be a little bit more complicated. And it's not overly complicated, but you need to make sure to submit clear, strong documentation that you can still meet that affidavit of support requirement. So the documentation that you submit depends on the type of self-employment that you have. If you are a sole proprietor, and that means that you have Schedule C on your U.S. tax returns, and I'm not a tax expert by any means, but if you're a sole proprietor, you will have Schedule C on your tax returns that shows the income of the business and the expenses of the business, and then basically what your net profit is for the business. One thing that we see a lot of times, not always, but a lot of times when we have that type of situation where our client, the U.S. citizen or green card holder, is self-employed and they have a sole proprietorship, is that they will deduct so many expenses that they really don't have a lot left in actual net income. That's a problem. It may be good. I can't speak as to the legality of it tax-wise, but it may be good for income tax purposes, meaning you're reducing your income, you're showing all these expenses and reducing your income, and then therefore reducing your taxable amount. Talk to your CPA or tax lawyer about whether you should be doing that or not. But as far as immigration goes, it's not great, or can be a problem, because it can reduce your income so much that you don't meet the income requirements for the affidavit of support. There is not one specific amount that you have to show for the affidavit of support. There's a table available that you basically have to show that you meet 125% of the federal income levels according to the number of people in your household, and that its own definition. That's something we help clients with all the time, walk through this process and make sure they're calculating it correctly and documenting everything correctly. But bottom line is, if you take too many deductions, if you have too many expenses on that Schedule C, then you may not have enough income. So we've seen that time and time again. So just be sure that if you are self-employed and you are a sole proprietor and you have that Schedule C on your individual tax returns, that you still have enough in net income to be able to show that you can support your spouse. Otherwise, you're going to have to get a joint sponsor or use assets or come up with another strategy to be able to meet that affidavit of support requirement. If you are a different type of entity, so for example, I am a PLLC, or not I am, but my company is a PLLC. But we're treated as an S corporation. So if you are not a pass, if you are an entity where you have a K1, if you're busy, you file your corporate taxes because you're treated as an S corporation, or you are an S corporation. If you have your corporate taxes and you get a K1, which is not the fiance visa, that's not what I'm talking about. I'm talking about the tax K1 document. But I receive a K1 that lists the net profit, and I also have a W-2 because I'm an employee of the company and I pay myself a salary. So in that case, it's most of the time it's easier to prove that the person, the U.S. citizen petitioner or permanent resident petitioner, can meet the affidavit of support requirements because they have both a salary and potentially profit, not always, but potentially profit from the business as well. Still, even if you are in that situation and you have a K1, you're treated as an S corporation. You still have to make sure, of course, that your income will meet the income requirements for the affidavit of support, but it absolutely is possible. So, and it's possible in addition to have, even if you're not self-employed, if you have other less traditional sources of income, it absolutely is possible. So over the years, we've had clients who have income from trust accounts. They are beneficiaries of a trust account and they have income from that, or they have rental income, but they don't actually work. It's kind of passive income, or they're retired. So they're all different scenarios where you have to be really, really careful and strategic in documenting that source of income, but it absolutely is possible to do, even if you don't have a traditional job where you get a W-2 and file your taxes and that type of thing. So it absolutely is possible. I hope that you have found this information helpful. If so, please share this video with a family member or a friend. Feel free to leave a comment if you have a question about an employment-based case or a family-based case. We can't give legal advice on this forum, but we're happy to answer questions if we can. And make sure that you're subscribed to this channel so you don't miss our next video. Our next video, or our next live, will be next Tuesday at noon Eastern, and I hope that you join us then. Otherwise, thank you for joining us now, whether you've caught us live or you're catching the replay. My name is Emily Sumner with Sumner Immigration Law, serving clients from around the world and around the United States with employment-based and family-based immigration cases. Until next time.